My name's David Levin and I'm on Michael Green's list, as you know. This is a breakfast seminar to attempt to elucidate the field of proportionate liability. Those of you who have slightly greyer hair will remember the collapse of HIH insurance and the political fallout that followed from that. Justice Ip was appointed to consider insurance and liability, as insurers were threatening to not provide cover in lots of circumstances. And he wrote a lengthy report, the Ip report, that you're probably familiar with, at least in part. In the course of that report, he was asked to address the issue of proportionate liability, or whether he was asked, he did, very shortly, in relation to personal injury issues. And he said, basically, thumbs down. Governments apparently, perhaps backstage under pressure from insurers, seem to take that as carte blanche to consider and provide legislation for proportionate liability, which first came in the amendments to the Building Act in construction cases. I don't really know why they decided that it was such an important field, but anyway, we now have Part 4AA of the Wrongs Act in Victoria, and I think I'm right in saying all the other states and territories have their own versions of the Act. And they're all slightly different, unfortunately. So this morning we have presentation from two members of the list. Matthew Kennedy, who has a general commercial practice and who read with Joe Salonides and was associate to Justice Marshall before that. Matthew will present the general outline of the legislation for those who are not familiar with it. After we've had a short break, we will hear from Fiona Spencer, who will discuss just a few recent cases so that you can see how the legislation gets applied in real-life circumstances. So without any more ado, Matthew, over to you.
Thank you, David. And thank you all for coming this morning in the wet weather. There's a paper you should have, which is effectively an abridged version of what I'm going to talk about. It should assist you if you want to refer back to anything that I say. Proportionate liability might seem to be a simple enough concept. However, it has raised a number of difficulties. Also, as a relatively new area of law, it can sometimes be overlooked. If missed, it can cause problems for both plaintiffs and defendants. It is imperative that practitioners are quick to identify when proportionate liabilities arise. Otherwise, plaintiffs may realise late that their claim could be significantly reduced by an insolvent concurrent wrongdoer. Also, defendants might miss out on an opportunity to minimise their exposure and place pressure on the plaintiff to settle at an early stage in the proceeding. There's insufficient time to discuss the various differences between the proportionate liability regimes in each jurisdiction. However, two key issues are common to all jurisdictions. That is, whether the claim is apportionable and who is a concurrent wrongdoer. I want to focus on these two issues. I will also discuss the key difference between the Victorian Wrongs Act and the other jurisdictions, being the requirement to join concurrent wrongdoers as opposed to notifying the plaintiff of concurrent wrongdoers. I will finish with the changes that have been proposed out of a review of proportionate liability by the Standing Committee of Attorneys General to give an idea of the direction which proportionate liability looks to be heading. Before the legislative encroachments into joint and several liability through contribution and more recently proportionate liability, a plaintiff who suffered damage due to the actions of multiple wrongdoers could take action against one wrongdoer and recover 100% of its loss. The defendant with the deepest pockets could find itself subject to a claim for the whole of the plaintiff's loss, despite being responsible for only part. The common law considered there to be three types of multiple wrongdoers. Joint wrongdoers, persons acting together that commit a wrong. Each is liable for the whole loss. There are no rights of contribution, and judgment against one releases the others. Several concurrent wrongdoers, who are persons that are responsible for separate wrongful acts which inflict a single loss. The wrongdoers are each liable for the full amount of the damage, but they are not jointly liable for the same wrongful act. Judgment against one wrongdoer does not release the other wrongdoers. And thirdly, several wrongdoers, which are persons who commit separate wrongful acts and inflict different damage. They are only liable for the damage they cause. Contribution was the first modification of the common law approach to multiple wrongdoers. Part 4 of the Wrongs Act in Victoria enables a defendant that is held liable for the plaintiff's loss to claim contribution from a person liable for the same damage. However, the defendant still carries the risk of being responsible for 100% of the damages awarded to the plaintiff if a concurrent wrongdoer disappears or is insolvent. Contribution continues to be relied upon where proportionate liability does not apply. Proportionate liability was first introduced into the Victorian Building Act and is most common in building cases. It was introduced more broadly in each jurisdiction in Australia from around 2003, including in Victoria under Part 4AA of the Wrongs Act. Its introduction followed pressure to make joint and several liability fairer, based on the view that a defendant should not bear the responsibility of other wrongdoers merely because it had the capacity to pay. Proportionate liability places the risk of insolvent concurrent wrongdoers on the plaintiff rather than on the defendant. If the claim is apportionable, the defendant's liability is limited to an amount reflecting the extent of the defendant's responsibility for the plaintiff's loss and damage. Proportionate liability provisions can be found in the various legislation in each jurisdiction, and in the paper I've provided there's a list of those. There are two threshold questions. Is it an apportionable claim that is not otherwise excluded by the legislation? And if an apportionable claim, are the other responsible person or persons concurrent wrongdoers? The Victorian proportionate liability regime does not apply to personal injury, vicarious liability and liability between partners, agency, claims involving findings of fraud, claims for which other legislation exclude the proportionate liability regime, and exemplary damages. Section 24AF of the Wrongs Act provides that proportionate liability otherwise applies to a claim for economic loss or damage to property in an action for damages, whether in tort, in contract, under statute or otherwise, arising from a failure to take reasonable care. Section 24AE defines damages as including any form of monetary compensation. This would include equitable compensation. Although the claim can be in tort, in contract, under statute or otherwise, some care is required. Contractual claims, for example, may not be for damages, nor involve a failure to take reasonable care. In Commonwealth Bank of Australia and Witherow, the bank claimed $150,000 against Mr Witherow based on his guarantee of the payment of all money that his company was liable to pay under an overdraft facility. Mr Witherow joined his accountant and as a concurrent wrongdoer, claiming his accountant had failed to provide him proper advice when he executed the guarantee. The Court of Appeal held that the bank's claim was not an action for damages, but an action for a sum certain. Also, the claim was not an action arising from a failure to take reasonable care, as the bank merely sought specific performance of the guarantee. Accordingly, it was not an apportionable claim. However, in Dartberg and Wealth Care Financial Planning, Justice Middleton stated in respect of a sum certain, His Honour said, "In my view, Part 4AA would also apply to a claim for a sum certain. Contrast Commonwealth Bank of Australia and Witherow, although the extended definition of damages does not seem to have been discussed. Therefore, it appears that the relevant consideration is not necessarily whether the claim is for a sum certain, but whether the claim is a form of compensation." In BHPB Freight and Cosgo Oceania Chartering, Justice Finkelstein looked at a breach of a warranty of authority. His Honour held that it was not an apportionable claim, as the breach of the warranty of authority did not depend on showing the defendant failed to act with reasonable care. Again, in George and Webb, a breach of trust for which equitable compensation was claimed was held not to be an apportionable claim, as the liability did not arise from a failure to take reasonable care. Dartberg is a key decision in the approach to be taken. Justice Middleton indicated that it may be necessary to look beyond the way the claim is pleaded and consider whether the claim is apportionable after all the evidence has been heard. His Honour states, "Even though claims in this proceeding themselves do not rely upon any plea of negligence or a failure to take reasonable care in a strict sense, a failure to take reasonable care may form part of the allegations or the evidence that is tendered in the proceedings. At the end of the trial, after hearing all the evidence, it may be found that Part 4AA applies." So it's important to think about what His Honour is saying. You don't really know whether a claim is apportionable until all the evidence is heard. Dartberg was applied in Reinhold and New South Wales Lotteries Corporation. Both negligence and breach of contract were pleaded. In respect of the breach of contract claim, Justice Barrett states, "On the findings actually made, however, there was a breach of contractual term because of actions entailing want of care rather than intention to breach or knowing breach. The breaches of contract to which the cancellation of Ticket B gave rise were of the same character as negligence. Each had as its central element failure to take reasonable care." So then looking at concurrent wrongdoers. Section 24AH of the Wrongs Act provides that a concurrent wrongdoer in relation to a claim is a person who is one of two or more persons whose acts or omissions caused, independently of each other or jointly, the loss or damage that is the subject of the claim. When identifying other concurrent wrongdoers, it is not enough to establish that the other person caused the loss. It is also necessary that the other person be, at least at some point in time, legally liable for the loss. In shrimp and landmark operations, it was held that the word caused in Section 87CB, subsection 3 of the Trade Practices Act, which is the apportionment provision, should be read as meaning to give rise to a liability. It may be sometimes difficult to establish the requisite duty of care in another person. For example, a defendant builder establishing the liability of its subcontractor to the owner, even though the subcontractor in part caused the damage. To cause the loss and damage that is the subject of the claim requires the concurrent wrongdoer to have caused the same damage. St George Bank and Quinnerts was heard before Justices Nettle, Mandy and Beach. The bank claimed breach of contract, negligence and misleading and deceptive conduct against a valuer, Quinnerts, for overvaluation of a property at $800,000. The bank advanced $600,000, and when the borrower defaulted and the bank sold the property, the highest bid was $490,000. Qunertz admitted its valuation was negligent, but sought to limit its liability on the basis that the failure of the borrower to repay the debt was also causative of the loss, and the borrower was a concurrent wrongdoer. Justice Nettle held that to cause the loss and damage that is the subject of the claim under section 24AH requires the same damage to be caused. His Honour came to this conclusion in large part by drawing an analogy with section 23B of the Wrongs Act, which deals with contribution claims, and unlike 24AH, uses the words the same damage. His Honour said that proportionate liability was not intended to do any more than what could be achieved under contribution. Justice Nettle concluded that the loss and damage caused by Qunertz arose from its negligent valuation, causing the bank to accept inadequate security. On the other hand, the loss caused by the borrower arose from the failure to pay the loan. As they were not the same damage, the borrower was not a concurrent wrongdoer. One way of looking at it is to consider the time at which the damage was caused. The negligent valuation caused the bank's loss when the bank provided the loan with inadequate security. This can be compared to the loss caused by the borrower, which did not occur until later on default of repayment. In Metzke and Allen and Sarli, Metzke and Allen were accountants for the Sarlis. This is another Court of Appeal case that came shortly after Qunertz. The Sarlis were directors and shareholders of Universal Logistics, a trucking company, and also provided the freight services for the company. Universal Logistics had an executive director by the name of Matthew Blizzard. Universal Logistics went into liquidation, and the Sarlis suffered loss through guarantees and unpaid accounts for freight. One of the Sarlis' accountants at Metzke and Allen had been attending the board meetings on behalf of the Sarlis leading up to the liquidation. The Sarlis claimed that their losses were caused by the negligence of the accountants by failing to advise the Sarlis of the poor financial position of the company. The accountants joined Matthew Blizzard to the proceeding as a concurrent wrongdoer. The Sarlis, however, chose not to make any corresponding claim against Mr Blizzard, despite him being joined. At first instance, the trial judge found that the accountants had been negligent, but also found that Blizzard was a concurrent wrongdoer by providing inaccurate profit statements to the board. The trial judge considered it was just to limit the accountant's liability to 30% of the loss. The Sarlis appealed and argued that Blizzard was not a concurrent wrongdoer, as Blizzard did not owe a duty of care to the Sarlis. And relying on the decision in Qunertz, the Sarlis also argued that the damage caused by Mr Blizzard was not the same damage as caused by the accountants. Although the accountants had not pleaded the facts necessary to establish a duty of care between Mr Blizzard and the Sarlis, the Court of Appeal accepted that it was open for the trial judge to find that Mr Blizzard had a duty of care and was therefore legally liable for the Sarlis' loss. As to whether the accountants and Blizzard caused the same damage, the Court of Appeal found that Blizzard's provision of inaccurate profit statements and the accountant's failure to advise the Sarlis about the financial position of the company did cause the same damage and distinguished Qunertz. So what may be at first blush, damages may appear to be the same. There's a need to consider the subtle difference that are discussed in Qunertz and discussed in Metzke and Allen in order to understand whether proportionate liability will apply to the cases you have before you. Unlike other jurisdictions, the Victorian proportionate liability regime requires the defendant to join concurrent wrongdoers to the proceeding unless the person is dead or wound up. under section 24AI. This onus on the defendant is beneficial to the plaintiff and creates a strong incentive for forum shopping. In addition to joining the concurrent wrongdoer, the defendant should plead in its defence the basis for the claim being apportionable and the joined party being a concurrent wrongdoer. Whether the defendant is required to plead against the concurrent wrongdoer depends on whether there is an alternative claim for contribution and what the court ultimately considers to be necessary in the circumstances. In the paper, there's a list of some cases that you'll find helpful in terms of considering that question. Once joined, the plaintiff must decide whether to seek relief against the concurrent wrongdoer. If the plaintiff does not plead or claim relief against the joined defendant, it will not be able to obtain any proportion of damages that the court determines to be the responsibility of that wrongdoer. In Metzke and Allen, although the accountants joined the executive director Blizzard as a concurrent wrongdoer, the Sarleys did not make a corresponding claim against Blizzard. Blizzard was found to be responsible for 70% of the loss, and consequently the Sarleys would not have recovered those damages. The proportionate liability regimes in all other jurisdictions do not require the defendant to join concurrent wrongdoers to the proceeding, but merely require the defendant to notify the plaintiff of concurrent wrongdoers. There are varying notification requirements between the jurisdiction. Generally, a costs risk is placed on the defendant for failing to notify the plaintiff within a reasonable time of the details of all possible non-party concurrent wrongdoers. It is not sufficient to simply name the person. The defendant must plead the identity of the concurrent wrongdoer, the basis for the cause of action, if it is tort, identifying the duty, its scope and the breach, and the damage, the aspects of causation, the alleged extent and proportion of the damages, and the causal connection with the damage said to be suffered by the plaintiff. The onus then shifts to the plaintiff to determine whether it will join and make a claim against the concurrent wrongdoer. Now, many practitioners are concerned about settlement, and settlement is often made harder by the proportionate liability regime, partly because it is difficult to judge whether and how apportionment is going to be applied. The greater the number of concurrent wrongdoers, the harder it is for each party to work out their level of commercial risk. The requirement in Victoria that concurrent wrongdoers be joined creates further difficulties in respect of settlement, principally due to the wording and operation of sections 24AI and 24AJ. Fiona Spencer will be discussing some cases in which these difficulties have arisen. In September 2011, the Standing Committee of Attorneys General, known as SCAG, released a consultation draft of proportionate liability model provisions, which arose from a review of all proportionate liability legislation with a view to achieving improvements and national consistency. It is not known when or if the proposed provisions will be adopted. The model provisions seek to create greater certainty as to what an apportionable claim is and give practitioners an indication of what to look out for by including in the relevant provision a list of examples. And you'll see in the paper the examples listed. They are not an exhaustive list, and the legislation notes that. The model provisions would amend the current definition of concurrent wrongdoer in the Victorian Wrongs Act to include the phrase substantially or materially similar loss or damage. This is broader than the requirement that a concurrent wrongdoer cause the same damage. The proposed change is clearly a response to the decision in Quinnertz, which it appears SCAG considered applied an overly narrow interpretation of who is a concurrent wrongdoer. The model provisions propose bringing the Victorian regime into line with the other jurisdictions by not requiring defendants to join concurrent wrongdoers, but merely notify the plaintiff. The model provisions also attempt to make clear how apportionment is to be applied against all wrongdoers, including those that have not been joined or have settled with the plaintiff. The provisions provide that in apportioning responsibility in the proceeding, the court must consider the comparative responsibility of each concurrent wrongdoer who is a party to the proceeding or about whom the claimant has been given information under Section 6, including any who have settled with the claimant. And the court may consider the comparative responsibility of any other concurrent wrongdoer, whether they may not be a party and they may not have been notified of. In respect of subsequent proceedings, the model provisions provide that where notice is given to the plaintiff of a concurrent wrongdoer and the plaintiff elects not to join them, the plaintiff would require leave of the court to bring any subsequent proceeding in respect of that wrongdoer. The provisions seek to address issues regarding the effect of subsequent proceedings and what the effect they have on previous findings by providing that the first judgment determines for all subsequent proceedings the maximum amount of the plaintiff's notional damages, the minimum proportionate liability of each concurrent wrongdoer who was a party to the first proceeding, and the minimum contributory negligence, if any, of the plaintiff. The exclusions from the proportionate liability regime are not currently uniform between jurisdictions. The model provisions would exclude consumer claims from proportionate liability, which are not currently excluded under the Victorian Wrongs Act. The Victorian Wrongs Act does not currently prohibit or permit contracting out. However, the model provisions propose that the ability to contract out of proportionate liability be available in respect of contracts above a certain value, which would be either $5 million or $10 million. This is intended to allow sophisticated parties to allocate risk. SCAG considers there to be a strong policy argument for proportionate liability applying to arbitrations and external dispute resolution schemes. The proposed model provisions provide a definition of court as including a tribunal, arbitrator and entities able to make a binding determination about liability. However, it is not clear how applying proportionate liability in arbitrations might operate in practice, given arbitrators cannot make a binding award against a concurrent wrongdoer who is not a party to the arbitration agreement. So bear in mind that these are merely proposed provisions to create some sort of consistency across the jurisdictions, and we have no idea whether they'll be brought in. Unfortunately, the list of issues in proportionate liability goes on. Fiona Spencer will look at some recent cases that deal with these further issues and the complexity and difficulties that proportionate liability creates. Thank you.